Hello, welcome to Chapter 4, Civil Liberties. Today we're going to be talking about civil liberties. These are individual freedoms, and they also place limitations on the power of government and ensure our rights to think and act without government interference. Some of these rights are spelled out in the Constitution, specifically in the Bill of Rights, and these include, for example, the right to express ourselves and choose our own religious beliefs. There is a difference, though, between civil liberties and civil rights. Civil rights refer to the extension of these liberties for all people, right? Basically ensuring equal rights for all members of society. So when we're talking about civil rights, we are referring to this requirement to treat all citizens equally, to apply laws fairly, and not to discriminate against any group of people based on gender or race, for instance. For example, you have the right to assembly, right? The right to gather together. That's part of the First Amendment. Now, did all people have this right? No, actually. It wasn't until the 14th Amendment in 1868 that African Americans and other minorities were actually considered citizens, and it required the states to extend federal rights to all people. So you have these civil liberties, right, these individual freedoms that need to be extended to all people via civil rights. So that's what civil rights refer to. So firstly, it was the passing of the 14th, 15th, and 16th Amendments that extended rights to all minorities. And of course, that was awesome, but it wasn't enough. In the civil rights movement in the 1950s and 60s in the U.S., a lot of people worked really hard to address the issues of racism and discrimination that was happening in society through culture and education, and not just the laws. So we'll learn the difference between de jure discrimination, like via laws, right, and de facto discrimination. So even when you have equal laws, people don't change all that much or all that quickly and are still racist. So you still have those kind of learned responses and learned behaviors. So laws don't necessarily make things right? So another example, similar for the 19th Amendment, right? Women could vote in 1920, but that's not enough. In some states, women couldn't even open up their own bank account or get a line of credit without a co-signer, of course, male. So in the 1960s and 1970s, you have this second wave of women's rights movement, which agitates for other laws and other rules in the workplace, for example. And we're going to talk about this, all about civil rights in Chapter 5. So today, we're going to actually be talking about the beginning of the Bill of Rights, so civil liberties, right? How they apply to the states and some of the specific liberties that we have. And there's going to be two main ideas or themes that you're going to see apparent throughout the PowerPoint. Firstly, the first 10 amendments are not standalone, they're not absolute, and they're not unlimited. They do require judicial interpretation, which we will analyze and discuss. Secondly, sometimes there's actually conflict among the different liberties, or these gray zones that require trade-offs among other important freedoms and realities. So, for example, is religious freedom in conflict with the right to choose abortion? Is there a trade-off between the right to bear arms and the need to control weapons getting in the hands of mentally unstable people? Is there a way to ensure freedom of speech without allowing slander or hate speech? Especially in this age of technology and the internet, there are new and significant challenges. So let's begin. Let's consider some history and evolution of the Bill of Rights. So for a long time, the Bill of Rights was only relevant to the national government. It only applied to the national government. The document actually begins with, Congress shall make no law. It actually doesn't say anything about the states. But in order for there to be fairness for all people, there has to be uniformity in the application of the law, right? You can't have a federal law that extends freedom of speech for people, and in Indiana, let's say the state government rules against it, right? Or you can't have freedom of religion, nationally speaking, except in Idaho, where there is a state religion, right? So to avoid the hundreds, if not thousands, of different interpretations and applications of the same federal laws at the state level, the Bill of Rights had to be nationalized. This fair treatment of everybody wasn't really addressed until after the Civil War. And we will talk more about this in the next chapter, but basically, since the passing of the 14th Amendment, a portion of which is on this slide here, it was made possible for the Supreme Court to require that states protect their citizens' basic liberties. And this is based on the idea that the state had to ensure the citizens' due process, or guarantee of a legal process and guaranteed liberties in the state, regardless of where it is, from California to Maine, it doesn't matter. So when an amendment or a portion of it was nationalized, that means that it became the law of the state too. And there could be no other interpretations of the law or any state laws that would conflict with it. And you can see a list of this on page 68, I believe, for your book. So when the First Amendment was nationalized, it applied to all the states, right? Again, Florida couldn't keep someone from printing something in a newspaper, right? The freedom of the press was national. It was incorporated, it was nationalized, applied to all the states. So let's start with the First Amendment here. Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. These are the democratic freedoms, the liberties that the founders believed to be necessary to maintain a representative democracy by ensuring a free and unfettered people. However, none of these liberties have escaped controversy, and none of them have been interpreted by the Supreme Court to be absolute or unlimited. So we'll talk about these details right now. Let's begin with the freedom of religion. There's basically two rules here. Firstly, that the church and the state are separate, and a guarantee of the free exercise of religion. So you have this establishment clause, which guarantees the division, right? There cannot be a church officially supported by the national government, and the government cannot establish an official religion. And then the free exercise clause is just that, right? Guaranteeing the free exercise of religion or no religion. However, when religious practice interferes with public welfare, or if it goes against public policy, the government can actually intervene. And I'll give you a couple examples here. These are real court cases, the real Supreme Court cases. And this shows how the freedom of religion is arbitrated in real life. And sometimes it gets pretty dicey. So I'm going to give you guys the situation, and you think about how you would arbitrate, right? You are the Supreme Court. And then I'll tell you how they voted. Okay, so in this first one, Minersville School District versus Gobitis. In this one, 2 children of a Jehovah's Witness family were expelled from school for violating a rule that required them to salute the flag each day. For a Jehovah's Witness, saluting the flag would constitute worshiping an idol, which their religion forbids. So their father brought suit, right? He sued the school district, claiming that this rule violated his children's freedom of religion, right? Because they're Jehovah's Witness, they cannot salute a flag, which they were required to do by their school because it is, against their religion, right? So if you were the Supreme Court, how would you rule? For or against? Do you think the children's rights were being affected here? You can maybe pause it if you really want to think about it, but I can tell you right now. So the court actually ruled against the suit and said that the kids were required to salute the flag, that it promotes national unity, which in turn fosters national security. You have to sometimes think about the context in which these Supreme Court cases were happening. I mean, what was the 1940s like? We were just about to get into World War II. There's a lot of nationalism. Unsurprisingly, at least to me, that this ruling was overturned a couple of years later, and you were no longer required to salute the flag. But That was an actual ruling. For a couple years it stood. All right, for Sherbert versus Werner, I'll tell you the story. In this court case, a Seventh-day Adventist, which is another type of religion, I think it's part of the Christian religion. Okay, so a Seventh-day Adventist whose Saturday is actually the Sabbath, right, not Sunday. This person was fired from a company for refusing to work on Saturday, again, her Sabbath day. She was denied unemployment compensation when she refused to take other jobs with compulsory Saturday hours, right? So they offered her some other jobs. She did not want to take them because they had the Saturday hours. And so she was denied unemployment because you cannot take unemployment if there's other jobs being offered to you, right? So how would you rule in this case if you were the Supreme Court? Would you vote for this woman, granting her unemployment benefits, or not? And why? Well, how do you think the court ruled? It actually ruled in favor of the woman, saying that the denial of benefits were a clear violation of her constitutional right. A lot of people in the actual classes I teach, the physical classrooms, are always surprised by this one. Then we have this 1990s case, the Department of Human Resources versus Smith. So in this situation, 2 Native Americans were fired from their jobs at a rehab clinic for testing positive for mescaline, the main psychoactive compound in the peyote cactus, which they had used in a religious ceremony, something Native American culture has been doing for centuries. They said that it was used for sacramental purposes in religious ceremonies. So they were fired, and then they were denied unemployment benefits. And these 2 Native Americans sued, saying that their denial of benefits was infringing on their constitutional rights, right, to the freedom of religion. So if you were the Supreme Court, how would you rule here? Well, the Supreme Court actually ruled in opposite to what they did in Sherbert versus Werner. It upheld the denial of the Native Americans' unemployment benefits. And this was basically because of the nature of the situation. So peyote is an illegal substance, right? It's illicit. And the court ruled that if you are infringing on religion, and it's not intentional, but rather this byproduct of a law prohibiting socially harmful conduct, and if it applies equally to all religion, then it's not unconstitutional. So basically, if you burden all religions equally with the same law, it's not unconstitutional, right? Like no religion can use cocaine or have some ritual killing or something, or some sort of ritual that is against the law, right? You cannot claim freedom of religion for something that is already illegal. Yes, okay. Now I'm going to give you a hypothetical. Let's say that there was new legislation being introduced for Alachua County, and it's being introduced by individuals of the Muslim faith. They propose that there should be a county-wide ban on most activities on Friday, given that Friday is a special day of prayer for the Muslim religion. So no alcohol sales, no sales of items that would be considered unnecessary work. Is this a denial of freedom of religion for individuals who are not Muslim? Why or why not? So most people who I ask would say, absolutely, this is a total, denial of the freedom of religion for other people. Of course, this is not real legislation, but there are parts of the country which ban some activities or sales of certain products not on Fridays, but actually on Sundays, traditionally the Christian Sabbath. These are called blue laws. Paramus, New Jersey actually has the most restrictive blue laws in the whole country. It bans all or nearly all retail business on Sundays. So does this now seem like a denial of religious freedom, but on those who don't practice the Christian religion? again, most people I ask in my physical classroom would say totally. But sometimes we don't realize, because, maybe Christianity is the dominant religion, or one that we've maybe culturally grown very accustomed to. So something like a Friday ban that corresponds to the Muslim religion becomes so impossible to even think about that it actually happening. But we do live in a country where, in some counties, we do have blue laws. There are, we are unfairly burdening people outside of the Christian religion. Something to think about. It's always important to think about things in a number of angles, especially from a minority perspective. So, two things we have to know about the previous rulings. I don't know if I mentioned this, but this Sherbert test, the Sherbert ruling here is actually coming back. So Sherbert versus Werner, right? It was that Saturday Sabbath case. This ruling actually made what was known as the Sherbert test, and it's this three-pronged test whether or not the government has violated an individual's constitutionally protected right to free exercise of religion. So you have these three sort of prongs, these three questions. Firstly, whether there is pressure by the government for someone to forego it, either indirectly or directly. Secondly, whether or not there is state interest that justifies the infringement. And thirdly, if no alternative form of regulation can avoid the infringement and still achieve the government's end. So say if there is another way that they can regulate something that does not infringe on religious exercise, they have to do that instead. Or if there's, let's say, other less restrictive means to further the law's interest or fulfill the law. Those are the sort of, three-prong kind of ideas that protect people's ability to, have the freedom of religion. So in the 1980s, the Supreme Court actually limited the use of the Sherbert test until the Smith case. Do we remember the Smith case? This one, right? So remember, they ruled in favor of the woman. They said, yes, infringing on your Sabbath day is not being respectful of the freedom of religion. But then in 1990, remember, the peyote smokers were denied unemployment. They said that peyote is illegal, right? So we cannot, that has nothing to do with religious freedom, right? We still have to follow the law, even if, even in your religion, right? So after the Smith case, though, again, basically said that you can't just use religious freedom to get around federal law, right? You can't just murder someone and say it's ritual killing. This was affirmed, right? And there was actually some backlash to this. Some people felt that the freedom of religion was sort of slipping, or they wanted to basically strengthen the idea of religion as a reason not to do something or to do something. Religion plays a really big role in politics, and particularly in this country. So after the Smith decision, Congress passed the Religious Freedom Restoration Act, the RFRA. This was in 1993, and this reinstated the Sherbert test. So it sort of expanded the ability for religious freedom. An example of this case was Gonzalez versus O Centro. So the federal government seized sacramental tea, which was actually had some illicit substance, it was some kind of drug, from a New Mexican branch of a Brazilian church. And the church members sued, and they said, well, this tea is for religious purposes, so we can use it. And the court, so it went up to the Supreme Court, and the court actually ruled in favor of the church, partially because the government failed to meet its burden under the RFRA, which is partially the Sherbert test, right? It basically said that the substance, that barring the substance, did not serve a compelling government interest. So this Sherbert test strengthens religious freedom, or the exercise thereof. So you'll be hearing about the RFRA. I will continue though. Unfortunately, I do not have time to keep talking about that. So let's just highlight some brief ideas about free speech. What is protected? So in the most basic understanding, the freedom of speech is the freedom to express your opinions, right? We'll get into the limitations of this on the next slide. So freedom of speech also includes, it includes verbal speech, right? But it also includes expression that doesn't necessarily include words, which could be called, which could be nonverbal, right? And it's called symbolic speech. So for example, the students who were protesting the Vietnam War, they wore these black armbands to school, right? Technically, they weren't talking, but they were expressing an idea, right? That they were against the Vietnam War. And the school tried to get them to remove them, but because of their First Amendment rights, they are allowed to express this opinion, right? So they were allowed to. You can even burn the American flag in protest. This was actually deemed part of your First Amendment right? Your freedom of speech. Commercial speech is protected with some restrictions. For instance, a company can have some speech for the intent of making a profit, right? They can try to convince you to buy something or buy a service, but they cannot advertise falsely. False advertisement is actually against the law. So, for example, there was a lawsuit against this company. I don't know if you guys are aware of these shoes. They make these minimalist shoes. This company called, I think, Vibram? Or maybe the shoes are called Vibrams. Well, this company made false and unsubstantiated claims about the health benefits of the shoes. They actually said that they reduce foot injuries and strengthen foot muscles. But this was actually proved to be not supported by scientific studies. And the lawsuit claimed that the company only made money because of these claims, right? Because they were claiming to have some significant health benefits if you use them. And so they sold the shoes under false pretenses, right? Which is actually illegal. So the suit was won by the people who purchased the shoes. There was a huge settlement to pay. Okie doke. Okay, so this is what's protected in a nutshell, but what is not protected? Well, obscenity, basically offensive sexual conduct, no technical decision, no technical definition as to what this means, and it has been left up to local and state authorities. For example, it's illegal to buy sex toys in Mississippi, Alabama, and Virginia, but it's legal everywhere else. There has been an evolution of thought, right? It differs geographically, and it also differs throughout history. So, for instance, this 1934 book by Henry Miller was banned at one point. It was deemed too bawdy and obscene. It had sexual content. But today, it's actually considered by some to be one of the top 10 or 20 greatest novels of the century. So things definitely change throughout time. The definition of obscene. What is considered obscene has a lot to do with pornography. For example, it is illegal to sell materials showing sexual performance by minors, of course, child pornography. Illegal to own or distribute or sell child pornography. Slander is also unprotected speech. Individuals are protected from defamation of character, right, which is defined as a false statement that hurts someone's reputation. And interestingly enough, because it's about protecting someone's reputation, legal slander is about public statements. So it has to be within earshot of another person, or of course, like printed somewhere, so more people, than the one person could read it or hear it or see it. It has to be some kind of audience. So if you call someone like dishonest or stupid to their face, it's actually not slander, but if a third party overhears, it is. And of course, it is still very much a gray area, and this sort of relates to the freedom of the press. There are laws against defamation in writing. This is called libel. and like slander, has to be seen by a third party. It's difficult because it's crucial to watchdog type of news sources and to the information providing roles of the press, that journalists can and should be able to write freely about the character and actions of those in public service, but not without responsibility, right? Of course, understanding that serious effects could be had on someone's career or reputation. But extending to individuals, it's still a gray area. For instance, we've all used Yelp, right? It allows for anonymous reviews. And of course, we've seen good and bad reviews. And depending on how many bad ones you see, it probably sways your decision about whether or not you're going to go patronize that restaurant or that business, right? And there has been issue taken by owners of companies and services who've been really unhappy with their negative reviews, saying that it leads, to lagging business, or that they even call it libel in some cases. And especially the fact that the reviews are anonymous. Interestingly enough, there was a suit brought up in 2014 against Yelp by a carpet cleaning business in Springfield, Virginia. He believed his negative reviews were fraudulent. He actually said that he thought they were posted by ex-lovers or his competition. So I don't know. What do we think? Could anonymity cause more instances of libel, right? There's no real responsibility if you get to be anonymous in writing something. Does it change, or should it change the way we see the freedom of the press or of speech? Definitely something to consider. Another one of those gray areas that we were talking about earlier. Another big issue when it comes to the press is when you get to the media coverage of criminal trials, for example. As you know, the Sixth Amendment guarantees the right to a free trial. And the First Amendment guarantees freedom of the press. Jurors are supposed to remain impartial, right? And they're supposed to just rely on the evidence introduced in court. But if they're going to read the paper or watch something on TV that talks about the trial, let's say it's a big trial, something kind of famous, they could be super influenced by that, right? If they're if these people, if the person on trial is being judged in the court of public opinion, is that, that's what we like to say in terms of the newspapers and the media, that could definitely sway the jurors, right? If everyone's saying that they're guilty or even innocent. So in years past, judges have issued gag orders, right? It actually restricts publication of any news about the trial or any pretrial hearings, trying to protect the accused person, right? Because everyone is innocent until proven guilty, right? There was actually this landmark case in 1976 that unanimously ruled that a judge's gag order does violate the First Amendment's guarantee of freedom of the press. So, again, kind of a push and a pull there, a bit of a gray area. The internet and the media has affected the right to a free trial, someone could argue, right? So something to consider. Your book doesn't go into the fine details of each of the amendments, so I'm just going to look at Amendments 4 through 8 as a whole, the rights of the accused. And this includes limits on the conduct of policy, pretrial rights of the defendant, and trial rights. So firstly, in terms of limiting the conduct of police and prosecutors, they need a warrant for searches and seizures. There needs to be probable cause for arrest. There's no, you cannot have coerced confessions, no entrapment. And after you're arrested and are being questioned, you have the right to be informed of your rights as well as what you're being held for. Pre-trial, there has to be the right of habeas corpus. What does that mean? Well, what does this translate to from Latin? You shall have the body, habeas corpus. It comes from English common law. Actually, first recorded use is in the 14th century. It was part of the Magna Carta. It was the idea to keep the king from holding someone prisoner indefinitely and without cause. So what does it mean? Well, basically, it keeps the government from holding you indefinitely without showing any cause. It requires the court to explain why you're being held, And you also have the right to proper arraignment. What is arraignment? You and your attorney appear in court. You hear the charges held against you and the reports of the case. And at this point, you enter a plea of guilty or not guilty. And this happening relatively quickly is within your rights. So you're not stuck in jail for months or even years just waiting to hear the charges. Unfortunately, this doesn't always happen in real life. You do hear about people being stuck in jail for years without even a trial. They're just waiting for their arraignment. Both pre-trial and during trial, you can plead the fifth, right, or remain silent as to not incriminate yourself, right? You don't have to admit guilt. Similarly, you have the right to a speedy trial, an impartial jury, legal counsel, no cruel and unusual punishment, though arguments have been made against the death penalty. That's another story. No double jeopardy basically means you cannot get tried for the same crime twice. If you're innocent, you're innocent. So it's illegal, no take backsies, and you are allowed to appeal. Another important thing is what's called the exclusionary rule. If for some reason the police, let's say, enters your house without a search warrant and finds some kind of evidence against you, drugs or something, I don't know, they cannot admit this in court. It's inadmissible. Only legally procured evidence can be presented in court. So this includes stuff that's found out by the police in violation of Miranda rights, or the information that the police have to tell you when you're arrested. Oops, I think I have it on here. There we go. If you are not read your Miranda rights, any information that you give cannot be used, right? But if you are read the Miranda rights, it says here, anything you say can and will be used against you in the court of law, right? That's why your lawyer normally tells you not to say anything. I'll leave it here. Whoops. The Ninth Amendment doesn't give any rights. It's more of a rule of how to read the Constitution. Basically, it states that the Constitution is not an exhaustive or full list of all the rights that people have, right? For instance, like without the Ninth Amendment, the federal government or the state government could technically say, well, listen, person, individual, citizen, it's not written explicitly in the Constitution that you have the right to X or the right to Y, so therefore you don't have it. But that's not the case, right? The Ninth Amendment says we have more rights than are listed in the Constitution. It is not a full list. The 10th Amendment has a two-part idea. Firstly, if there is a power that is not mentioned specifically, and if it's not a federal power, right, let's say like foreign policy, for example, then that power goes automatically to the states or the people. So there's a constriction or limit on the federal government here, right? So if there's a power that is not a federal power, it automatically goes to the states or the people. And there's kind of a second implicit idea here, the 10th Amendment. It's this reaffirmation of the nature of the federal system. So it declares sort of matter-of-factly that there is a relationship between the federal and the state governments, right? Just to wrap up here, something that your book actually doesn't, surprisingly to me, doesn't touch on is the Second Amendment, the right to bear arms. The Second Amendment reads, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Something to consider. Does this refer to collective rights as part of a militia? Or, the way that some people see it today, is it referring to individual rights? There are some who think of the right to bearing arms as an outdated concept. That's referring to muskets and militias, something, a power like the U.S. does not need. We have the military, we have the police. There's really no need for individual citizens to be armed. There was a sort of a different historical context in which the right to bear arms was, more necessary back then. And on the other side, you get more of this idea that these are individual rights that should always be protected at all costs. Another sort of caveat to think about, things are definitely, more complicated than they seem, especially as technology has changed really immensely from the 1700s and 1800s. Thinking about the actual arms we're talking about. What about assault weapons or any kind of automatic or semi-automatic weapons? Are these covered under the Second Amendment rights? Obviously, these are new technologies, right? We did not have that back in that day. And then thinking about, the issues that result from guns. Active shooter events have become more common in the recent years. There's an FBI report in 2013 studying active shooting situations for 13 years between 2000 and 2013, and it found that these kind of incidents were happening more and more frequently. The first 6 years, the study found an average of 6.4 active shootings per year, while the last 7 years found the number jumped all the way up to 16.4 incidents per year. An active shooting incident is defined as an individual actively engaged in killing or attempting to kill people in a confined and populated area. I think I have another slide here. Now, does it matter that most of the weapons are obtained legally? For instance, Mother Jones tracked and mapped shooting sprees over the last 3 decades, from 1982 to May of last year, and they counted at least 61 mass murders carried out with firearms across the country, with the killings unfolding in 30 states from Massachusetts to Hawaii. There was a Congressional Research Service report published in 2013, which counted 78 incidents over about the same period, in which 547 people were killed. And definitions of mass shootings do vary. The report excludes those for whom terrorist ideology or criminal profit was a motivation. So it wasn't terrorism, and it wasn't like crime, right? It wasn't like a robbery or something. So does this mean anything for the Second Amendment? As we've seen in this chapter, there is sometimes a gray area between liberty and security, and between many of the freedoms within the Bill of Rights. There is no easy answer, and oftentimes things can change throughout history. Something to consider when we are reading and learning about these freedoms listed in the Bill of Rights, right? They're not absolute, and they do need to be arbitrated by the Supreme Court. So I've gone over a little bit my time, but hopefully that gave you a nice overview of Chapter 4, Civil Liberties. You're ready for your quiz. As always, any questions, please let me know.